Confidentiality agreements don't ordinarily last forever. In fact, they usually set a term of a year or 2 or 3 or 5, but a set term during which information disclosed might be considered confidential information. In another video, I've discussed which particular information is being covered, but it's important to understand that only information that is disclosed during the term of the confidentiality agreement will be subject to its protections. Sometimes confidentiality agreements are signed a little after information has already been disclosed, and the agreement might contain information saying that that information should be subject to the agreement as well. But information which is disclosed after the agreement has expired or been terminated is ordinarily not subject to any protections via that agreement itself. So information that's disclosed during the term of the agreement is subject to its protections, but for how long? This is the question. They often do not specify that protected information, that is, information disclosed during the term, that the protected information should remain protected even after the agreement is terminated. And that might be fine. You should always consider the context, the particular circumstances, and the relationship of the parties, and of the nature of the information itself. It might be fine that it be disclosed or no longer protected after the agreement ends. But in the tech world, we're often disclosing information about our technologies, that is, let's say the source code to our software, or information about how we've accomplished some technical feat, and we want that information protected. Is it as simple as saying that information that is protected during the term should remain subject to the protections after the term? Well, yes, in fact it is, if the agreement says that, but very commonly an agreement will include what we call a sunset provision, saying that information is protected for a period of, say, 3 years following its initial disclosure. Or it might say that it's protected for a period of up to 3 years following the expiration or termination of the non-disclosure agreement, at which point the recipient of that information would be free from any constraints under the NDA to use that information. They could use it in any way without restriction, unless they required a patent license or some other form of license to make use of the information. They could at least disclose the information after the sunset has occurred. Well, this is uncomfortable if you've got technical information, trade secret information, which is going to continue to have value after the sunset. And so you should always look out for those sunset provisions, knowing that following the expiration following the sunset, those restrictions are off. And so I'll often modify a sunset provision during negotiations so that we have 2 categories of protected information, that which is technical in nature and that which is non-technical in nature, perhaps an employee list or a customer list, or perhaps some financial data about last quarter's performance. 3 years from now, or 3 years after the expiration of the agreement, whenever the sunset occurs, it would probably be fine for that information to be disclosed. But technical information, such as the source code to software, will retain value ordinarily after that sunset would have occurred, and so we will try to extend that. As the discloser of information, we're interested in making sure that the protection endures so long as the confidentiality of that information provides added value, so for so long as it is considered a trade secret under applicable law. So we'll try to watch out for sunset provisions in our agreements, understanding that only certain information disclosed during the term, sometimes information disclosed prior, will be protected, and then we'll have to consider how long it should be protected following expiration or termination.